Michigan seller disclosure requirements. Question 1. During a lease negotiation in Dearborn, a licensee encounters a rule involving whether a person may simultaneously hold salesperson and broker licenses. Which response follows Michigan law, while the file concerns a urban infill property, a fair minus housing complaint record, and a security minus deposit question? Option A. The restriction applies only to associate brokers. Option B. Both licenses may remain active indefinitely. Option C. Both are allowed if issued in different counties. Option D. The person may not hold both license types at the same time. The correct answer is option D. The person may not hold both license types at the same time. Michigan separates the salesperson credential from broker minus level licensure. A written office procedure should produce the same result in comparable transactions. County location does not alter the statewide licensing classification. Question 2. A salesperson is preparing for a seller consultation in Battle Creek. Which statement correctly addresses the usual validity period of initial salesperson pre-licensure education, while the file concerns a subdivision lot, a brokerage policy manual, and a dual minus representation concern? Option A. 5 years from examination. Option B. 30-6 months from course completion. Option C. 1 year from application. Option D. 6 months from enrollment. The correct answer is option B. 30-6 months from course completion. Initial salesperson coursework remains usable for a 3-year period after completion. In the described setting, the brokerage should document the step and apply it before moving forward. The examination and application have their own shorter validity periods. Question 3. Which Michigan requirement should control when an associate broker deals with the usual validity period of a passing salesperson exam result during a listing presentation, while the file concerns a rural acreage, a continuing minus education certificate, and a protected minus class inquiry? Option A. 3 years from testing. Option B. 1 year from the passing date. Option C. 90 days from testing. Option D. No expiration after passing. The correct answer is option B. 1 year from the passing date. A passing licensing score is time minus limited even though it has been reported to the application. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Course validity and license minus cycle length do not extend the score period. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. At a buyer consultation, the brokerage discusses the usual validity period of a paid salesperson application. Which conclusion is most accurate, while the file concerns a single minus family residence, a closing statement, and a disputed repair credit? Option A. 2 years from course completion. Option B. Until the applicant chooses to reactivate it. Option C. 1 year from the payment date. Option D. 30 days from submission. The correct answer is option C. 1 year from the payment date. The online application remains open for a defined 12-month period. For exam purposes, focus on the regulated relationship rather than an informal business custom. A valid course certificate does not keep an expired application open. Question 5. A compliance question in Kalamazoo concerns the requirement for a non-Michigan resident applying for a salesperson license. Which action or statement is appropriate, while the file concerns a small apartment building, a fair minus housing complaint record, and an electronic signature? Option A. Submit a consent to service of process. Option B. Establish a Michigan homestead. Option C. Open a branch office. Option D. Appoint a county assessor. The correct answer is option A. Submit a consent to service of process. A non-resident applicant must provide a mechanism for legal process connected to Michigan regulation. The transaction context changes the facts, but it does not change the underlying licensing duty. Residency in the state is not itself a condition for salesperson eligibility. Question 6. How should a Michigan listing licensee handle a situation involving the allowed address arrangement for a salesperson or associate broker, while the file concerns a office condominium, a brokerage policy manual, and a referral arrangement? Option A. Every licensee must use a storefront. Option B. A post-office box may be used. Option C. Only a broker company may use a post-office box. Option D. An out-of-state address automatically voids the license. The correct answer is option B. a post-office box may be used. Individual salespersons and associate brokers have more flexible address options than brokerage offices. A written office procedure should produce the same result in comparable transactions. The mailing choice does not remove non-resident service process requirements. Question 7. Which choice best applies the state rule concerning the process used when a salesperson changes employing brokers to a brokerage audit, while the file concerns a condominium unit, a continuing education certificate, and a team social media post? Option A. Submit a ME Plus modification request for a license transfer. Option B. Transfer the license through the County Register of Deeds. Option C. File a new pre-licensure course application. Option D. Keep both employers until renewal. The correct answer is option A. Submit a ME Plus modification request for a license transfer. Employment changes are recorded through the state licensing system. In the described setting, the brokerage should document the step and apply it before moving forward. A deed-recording office has no role in transferring an occupational license. Question 8. A file from Pontiac raises an issue about the status that may follow removal by an employer before expiration. Which answer identifies the governing requirement, while the file concerns a retail suite, a closing statement, and a record inspection request? Option A. Permanent revocation. Option B. No employer status. Option C. Automatic broker status. Option D. Inactive county registration. The correct answer is option B. No employer status. Michigan does not offer a formal license minus escrow classification for salespersons. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. That status does not authorize independent real estate practice. Are you looking for real estate actual questions? Visit our website pokerexams.com to access real estate study guide with actual questions and answers. Scan the QR code or click the link in the description to get real estate answer key today. Question 9. Before completing a renewal review, which rule should the team member apply to the standard salesperson license renewal cycle, while the file concerns a manufactured home site, a fair housing complaint record, and a branch office distance issue? Option A. 3 years. Option B. 1 year. Option C. 2 years. Option D. 5 years. The correct answer is option A. 3 years. Michigan salesperson credentials operate on a 3-year renewal cycle. For exam purposes, focus on the regulated relationship rather than an informal business custom. The cycle length does not eliminate annual subject requirements within continuing education. Question 10. A Michigan exam candidate reviews a scenario involving the total continuing education expected within a full 3-year cycle. Which option reflects the current licensing framework, while the file concerns a 2-unit rental, a brokerage policy manual, and a financing contingency? Option A. At least 12 clock hours. Option B. At least 6 clock hours. Option C. At least 18 clock hours. Option D. At least 40 clock hours. The correct answer is option C. At least 18 clock hours. A full renewal cycle requires 18 hours of eligible professional education. The transaction context changes the facts, but it does not change the underlying licensing duty. Pre-licensure coursework cannot simply be relabeled as renewal credit. Question 11. The broker's policy manual addresses the annual law minus related continuing education component. Which provision should it contain, while the file concerns a historic residence, a continuing education certificate, and an unrepresented consumer? Option A. No annual subject requirement. Option B. 4 hours of appraisal each year. Option C. At least 2 hours involving laws, rules, and court cases. Option D. 1 hour every 3 years. The correct answer is option C. At least 2 hours involving laws, rules, and court cases. Each year of the license cycle includes a real estate law component. A written office procedure should produce the same result in comparable transactions. General elective hours do not replace the designated legal instruction. Question 12. A regulator asks about the annual fair housing continuing education component during a brokerage review. Which response demonstrates compliance, while the file concerns a student rental, a closing statement, and a confidential price limit? Option A. At least 1 hour involving fair housing compliance. Option B. 3 hours of advertising only. Option C. No fair housing instruction after licensure. Option D. 1 hour of tax preparation. The correct answer is option A. at least 1 hour involving fair housing compliance. Housing minus equality instruction remains an annual part of professional education. In the described setting, the brokerage should document the step and apply it before moving forward. A general business course does not satisfy this designated subject by itself. Question 13. Which statement would be safest for an associate broker to follow when the timing of continuing education in relation to online renewal becomes relevant, while the file concerns a vacant commercial parcel, a fair minus housing complaint record, and a change of employing broker? Option A, a complete education only if audited. Option B, substitute a new licensing examination. Option C, renew first and complete education later. Option D, finish the required education before submitting the renewal. The correct answer is option D. Finish the required education before submitting the renewal. The licensee must be able to truthfully attest to educational compliance during renewal. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. An audit is a verification mechanism rather than the event that creates the obligation. Question 14. A dispute arises during a team training over the record minus retention period for proof supporting a continuing education certification. Which principle resolves the issue, while the file concerns an industrial site, a brokerage policy manual, and an owner minus licensee conflict? Option A, permanently with the county clerk. Option B, until the license card arrives. Option C, at least 4 years after the certification date. Option D, 1 year after the course. The correct answer is option C, at least 4 years after the certification date. Licensees are responsible for keeping acceptable evidence of completed renewal education. For exam purposes, focus on the regulated relationship rather than an informal business custom. Course providers or local offices do not replace the licensee's documentation duty. Question 15. In novi, a buyer representative must decide how to proceed with the consequence of a license being revoked before a new application. Which decision is consistent with Michigan requirements, while the file concerns a new construction home, a continuing minus education certificate, and an expired license issue? Option A, wait at least 3 years after service of the final order. Option B, wait 30 days. Option C, reapply immediately after paying a fee. Option D, complete only a transfer request. The correct answer is option A, wait at least 3 years after service of the final order. Revocation creates a statutory waiting period before a new license application. The transaction context changes the facts, but it does not change the underlying licensing duty. A routine transfer or fee payment cannot bypass the sanction. Question 16. Which exam answer accurately classifies the rule involving the education calculation for relicensure when expiration was less than 3 years ago, while the file concerns a mixed minus use building, a closing statement, and a property minus management payment? Option A, repeat only the original exam. Option B, no education is required. Option C, complete 40 hours for every missed month. Option D, complete 6 hours for each elapsed year or partial year. The correct answer is option D, complete 6 hours for each elapsed year or partial year. Recent relicensure uses a year minus by minus year continuing education calculation. A written office procedure should produce the same result in comparable transactions. The original salesperson course is not automatically the only route in this situation. Question 17. A new policy is being drafted for the additional choices after a license has lapsed for 3 years or more. Which language belongs in the policy, while the file concerns a cooperative unit, a fair minus housing complaint record, and a delayed possession term? Option A, reactivate through a local association. Option B, use an employer transfer without review. Option C, meet the stated relicensure education or examination pathway. Option D, pay a late fee only. The correct answer is option C, meet the stated relicensure education or examination pathway. A long minus expired credential requires more than a routine renewal transaction. In the described setting, the brokerage should document the step and apply it before moving forward. Local membership does not restore state authority to practice. Question 18. During team training, the supervising broker tests knowledge of the agreement that defines brokerage services for a client. Which answer should the team select, while the file concerns a farm parcel, a brokerage policy manual, and a cooperating brokerage? Option A, a verbal promise from a customer. Option B, a written service provision agreement. Option C, a tax assessment notice. Option D, an unsigned advertising draft. The correct answer is option B, A written service provision agreement. Michigan brokerage services are organized through an agreement identifying the relationship and services. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. A public advertisement or assessment record is not a substitute for the brokerage contract. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee A-Pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A consumer asks the brokerage to explain the function of a limited service agreement. Which explanation reflects Michigan law, while the file concerns a lakefront cottage, a continuing education certificate, and a rejected counteroffer? Option A. Permits specified services to be knowingly waived in writing. Option B. Authorize unlicensed practice. Option C. Transfer the broker's license to the client. Option D. Remove every duty of honesty. The correct answer is option A. Permit specified services to be knowingly waived in writing. A limited service arrangement narrows selected brokerage services through a documented waiver. For exam purposes, focus on the regulated relationship rather than an informal business custom. Core legal obligations and licensing requirements are not erased by the reduced scope. Question 20. Which compliance step is required when the transaction facts involve the purpose of a property management employment contract, while the file concerns a townhouse, a closing statement, and an assumed business name? Option A. Create a mortgage lien. Option B. Replace all lease agreements. Option C. Define the broker's management duties and handling of property funds. Option D. Transfer title to the property manager. The correct answer is option C. Define the broker's management duties and handling of property funds. Property management for another is based on a written employment arrangement. The transaction context changes the facts, but it does not change the underlying licensing duty. It does not convey ownership or eliminate contracts with tenants. Question 21. A licensee notices a potential problem involving the source from which a salesperson may accept brokerage compensation. Which response should occur first? While the file concerns a urban infill property, a fair housing complaint record, and a security deposit question? Option A. A buyer directly without broker involvement. Option B. Any cooperating salesperson. Option C. A home inspector. Option D. The employing real estate broker. The correct answer is option D. The employing real estate broker. Salesperson earnings for regulated activity flow through the employing brokerage. A written office procedure should produce the same result in comparable transactions. A transaction participant cannot bypass the broker by paying the salesperson directly. Question 22. The state portion of the exam presents facts about payment of commissions earned before a salesperson left a brokerage. Which result is supported, while the file concerns a subdivision lot, a brokerage policy manual, and a dual representation concern? Option A. Payment is allowed only after relicensure. Option B. The former broker may pay the income that was earned during employment. Option C. The new broker must collect it first. Option D. The money must be forfeited. The correct answer is option B. The former broker may pay the income that was earned during employment. Compensation already earned under the former employment relationship may still be distributed afterward. In the described setting, the brokerage should document the step and apply it before moving forward. A later transfer or licensing change does not automatically cancel earned income. Question 23. Which brokerage practice properly addresses the ability to sue for a brokerage commission in the Pontiac transaction, while the file concerns a rural acreage, a continuing education certificate, and a protected class inquiry? Option A. Only the buyer's signature is needed. Option B. An oral advertisement establishes entitlement. Option C. A license is irrelevant in a compensation action. Option D. Licensure must be alleged and proved for the regulated services. The correct answer is option D. Licensure must be alleged and proved for the regulated services. A person seeking judicial recovery for regulated brokerage work must establish lawful licensure. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Advertising or a participant's signature cannot replace occupational authority. Question 24. A licensee is comparing 4 procedures related to the size of the employing broker's business name in an advertisement featuring a salesperson or team. Which procedure is lawful, while the file concerns a single family residence, a closing statement, and a disputed repair credit? Option A omitted if a logo appears. Option B equal to or greater than the affiliated name. Option C smaller than every team name. Option D shown only after a consumer clicks. The correct answer is option B, equal to or greater than the affiliated name. Michigan advertising must make the responsible brokerage meaningfully visible. For exam purposes, focus on the regulated relationship rather than an informal business custom. A logo or later webpage does not cure an initial display that hides brokerage identity. Question 25. At the end of a property management meeting, the parties question the contact information required in a broker's real estate advertisement. Which statement provides the best guidance? While the file concerns a small apartment building, a fair-housing complaint record, and an electronic signature. Option A. The salesperson's birth date. Option B. Only a social-media username. Option C. A lender's routing number. Option D. The broker's telephone number or street address. The correct answer is option D. The broker's telephone number or street address. Broker advertising must provide a direct identifying contact element for the licensed firm. The transaction context changes the facts, but it does not change the underlying licensing duty. Personal data and unrelated account information do not serve the regulatory purpose.